Welcome back to the Law and Crime Network. I'm Heather Hansen, and we are in the midst of a very important and very interesting case coming out of New Jersey. It is a case that involves a husband and wife, estranged but still together, and they are, the case is against the man that you're seeing here on the screen, Jeremiah Monell. He is accused of killing his wife, Tara O'Shea Watson. Tara Watson is who you see there on the screen right now, and this case is going to have a whole lot of interesting aspects, especially when it comes to the family and what is going on in that home, because we are likely going to hear from the young son of Jeremiah, a 12-year-old child who witnessed at least part of the incidents that happened in this case and was a key witness with respect to this case. But before we get to that, we're going to take you straight to the top crimes of the day.
Here are today's top crime stories trending on Law&Crime.com and across the country. A couple in Georgia who went missing earlier this week were found dead from what authorities believe was a murder-suicide. Investigators believe two bodies they discovered in a burnt truck on a property in Crawfordville are those of missing Stephen Rhodes and his wife, Melissa. The bodies were taken to a crime lab in Decatur, where authorities hope to determine a cause of death. Prosecutors in Indiana filed murder charges against a 21-year-old soldier accused of killing his wife and fleeing to Thailand. Peter Van Bawi Lien, an active duty soldier with the U.S. Army, is accused of killing his wife, Quang Par, whose body was discovered in a trash bin in Indianapolis on December 23rd. Airline records reportedly show Lien flew to Bangkok on December 24th. Lien was arrested in November on charges he assaulted Par and is now wanted for murder and military desertion.
John! Wait!
Hey, no!
A customer in a Florida McDonald's is facing charges after a video of him assaulting an employee over straws went viral. The customer, 41-year-old Daniel Taylor, is seen grabbing employee Yasmin James at the St. Petersburg restaurant, reportedly because plastic straws weren't readily available. That's when things got crazy.
Hey, no! Get the police. Let her go.
Taylor now faces 2 counts of simple battery. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Well, that's quite a scene going on in that McDonald's. Welcome back to the Law and Crime Network. As we're here on this break in this very interesting case against Jeremiah Monell, we want to show you some of the top trials of 2019. So take a look at this as we wait to get back into that courtroom in New Jersey.
I'm Anthony Velez for Law and Crime, and here are your top 5 caught on court camera moments of 2018. Number 5.
God! God! God!
A suspect in a double murder was denied bond in a Florida courtroom after screaming from a wheelchair during his bond hearing. 19-year-old Damon Kemp is accused of the fatal shooting of 19-year-old Trey Ingraham and 19-year-old Jordan Payton at their home in Daytona Beach. Kemp, who was reportedly staying with the 2 victims at their home, is seen being disruptive during his bond hearing.
God! God! God!
I've reviewed your arrest warrant to determine whether there's probable cause for your arrest.
That?
Kemp now faces 2 counts of second-degree murder. Number 4. A crazy melee unfolded in a Florida courtroom after a guilty verdict was read in a murder trial. Video shows the eruption of violence after the verdict was delivered in a murder trial with 4 defendants. 3 of the co-defendants can be seen brawling with their own defense attorneys and court bailiffs. Once order was restored to the court, all 4 defendants were sentenced to life in prison. The 4 men were convicted in the shooting death of 28-year-old Courtney London in 2016. Number 3. A man in Oregon was caught on camera trying to grab an officer's service weapon during his trial in a Lincoln County courtroom. 27-year-old Scott Patrick Lemon can be seen quickly standing up and unsuccessfully lunging for the gun of a Newport police officer before being tackled to the ground by another officer. Lemon was convicted for robbing 2 guests at a beachfront condo in Newport with a fake gun. Number 2. A judge in Washington state played the role of court officer and chased down 2 handcuffed inmates who made a run for sweet freedom in his courtroom. The inmates, 22-year-old Tanner Jacobson and 28-year-old Cody Howard, saw an opportunity to escape and went for it. That's when Judge R.W. Buzzard surprised everyone and leapt into action, chasing down the fleeing inmates.
Buzzard was able to apprehend Howard before he exited the building. Jacobson was caught by officers a few blocks away. Here's the number one caught on court camera moment.
We, the jury, find the defendant, Daniel Villegas, not guilty of...
Daniel Villegas was found not guilty of murder, ending a 25-year saga that included 3 trials and appeals. Villegas faced capital murder charges for the 1993 fatal shooting of 2 teens in El Paso and served 18 years in prison prior to his acquittal. Villegas, who was 16 at the time of the killings, faced his first trial in 1994, which ended in a mistrial, but was convicted during a second trial a year later, receiving a life sentence. The bittersweet moment of his acquittal was caught on court camera.
We, the jury, find the defendant, Daniel Villegas, not guilty of...
That was the number one caught on court camera moment. I'm Anthony Velez for Law & Crime.
Well, those were some of the top caught on camera moments of the past year, and we have some very interesting moments coming up for you this year. And in fact, next week we have a trial that is going to be one that you are not going to want to miss. This is the case against Jason Dalton. That is the man accused of the mass shooting in Kalamazoo. Let's watch a little bit about that case that's coming up just next week.
A former Michigan Uber driver could get life in prison for a 2016 shooting rampage that left 6 people dead. Prosecutors say Jason Dalton killed 6 and critically injured 2, including a teenage girl. The frenzy began while Dalton was transporting a passenger from Kalamazoo College. Dalton claimed he began seeing strange symbols on his phone, and a sensation came over his body. He began driving erratically through the streets, frightening the rider, who was eventually able to escape. Dalton told police he drove back to his home and began preparing his weapons. He said he drove to an apartment complex intending to pick up a rider. Instead, he found 25-year-old Tiana Carruthers. Dalton shot her multiple times. Tiana managed to survive. Dalton continued, reportedly fatally gunning down 53-year-old Richard Smith and his son, 17-year-old Tyler Smith, at a car dealership around 10 p.m. The final shooting occurred less than 20 minutes later, when Dalton allegedly shot 4 women and a young girl in a Cracker Barrel parking lot. Sisters-in-law Mary Lou and Mary Jo Nye, Dorothy Brown, and Barbara Hawthorne were among the dead. Barbara's family friend, a 14-year-old, sustained a gunshot wound to the skull, but managed to survive. In interviews with police, Dalton said it was like it wasn't even himself. He further explained to a psychiatrist, "It almost seemed like my phone could control me," despite reportedly having no history of psychiatric delusions. In spite of his claims, he was found competent to stand trial in April 2016. An appeals court threw out the confession Dalton made to police, citing Miranda violations. Dalton pleaded not guilty to the charges. His defense attorney has expressed intent to use an insanity defense. Dalton faces 6 counts of murder, 8 weapons charges, and 2 counts of assault with intent to murder. For the Law & Crime Network, I'm Aaron Keller.
And that case starts just next week. I want to talk just a little bit about that case with our guest today, Sanford Rubenstein. You are here today, a civil litigator, and have certainly handled many cases in the courtroom and picked many juries. In a situation like that one, where you've got a defendant who's accused of a mass shooting, multiple victims, and is likely to use an insanity defense, how difficult is it going to be to get a jury?
Well, I would suggest that the defense has their work cut out for them. Yeah. Because to get a jury that's unbiased in a situation, especially in today's climate in which there's a mass shooting, is a difficult task. Not impossible, but difficult.
Yeah, and it's going to, as you said, it's going to be a difficult job with lots of really in-depth questions during voir dire, during jury selection, to try to make sure that you're getting the, if not a fair jury, at least the most fair jury that you can get going into the box.
Or at least the jury that says they're going to be fair.
That's right. That's right. Which is oftentimes the best you can hope for, especially in a case like this. Now, do you think that they'll start to lay the ground on both sides for the insanity defense?
Well, there's no question that while you're not supposed to, jury selection is when good lawyers lay the groundwork, lay the foundation for what the defense is going to be.
Absolutely, absolutely. Well, we're going to be back with a whole lot more about that case starting next week. Right now, we are waiting for them to go back into the courtroom and end their break in this trial against Jeremiah Monell. We're going to go to a quick break, and when we come back, we'll see if they're back in the courtroom. So there you go, ladies and gentlemen. That is the crux of the prosecution's case. I want to bring in our guest, Sanford Rubenstein. Sanford, what do you think about the prosecution's case? It seems to me that it's close to a slam dunk.
Well, it's very, very important for them to have the believability of this 12-year-old boy assessed by the jury as someone who is credible and also someone who saw what was there to be seen and didn't err at all in what he saw.
Well, and it's so difficult when you have young children who have to testify, much less when they are the key to the entire case. You know, one of the things that I do in my work is I work with the Support Center for Child Advocates, and we work with kids in the system. And it's so foreign to them, and to tell their story to this jury, this box full of people, and such a very tragic and psychologically damaging story.
Well, I think it also must be very difficult for this 12-year-old boy. He's testifying against his father.
Well,
if his testimony is believed, his father could go to jail for life without parole. That's got to be psychologically difficult for a 12-year-old boy.
We're assuming that he's going to testify. Do you think that there's any way around that, Sanford? I mean, if other people, like the neighbor to whom he said, I just saw daddy kill mommy, that's hearsay, right?
Well, and so, in opening, if the jury expects from the opening to hear this testimony and it doesn't come about, that's a problem for the prosecution.
Absolutely. But he didn't say you're going to hear from little Maya, the son. He said you will hear. But now I can't see a way around the hearsay. You know, we know hearsay is when someone who did not speak the words is actually testifying to them. So that's going to be a difficult way for them to get around the hearsay unless the son himself testifies. It looks like we're live back in the courtroom, so we'll come back and talk about this. But we want to make sure we don't miss a minute of the testimony in this case. So let's go right back. All right, ladies and gentlemen, we're going to take you to a break, but before we do, we're going to hear from Aaron Keller about what he has coming up for us today in the Daily Debrief. Aaron?
Heather, good afternoon. Coming up tonight on the Debrief, we're going to take you through everything that's happened in this critical day one of the Jeremiah Monell trial out of New Jersey. There's the defendant sitting stoically in court. We're going to bring you back to everything the prosecution promised to show during opening statements and how the defense is planning to get out from underneath the crushing weight of evidence in this case, because this is a very strong case for the state. That's coming up on the Debrief. Also, a possible break in the disappearance of Kelsey Barrett. We know that the fiance, Patrick Frazee, is under arrest, charged now with murder and other charges related to the presumed death of his fiancée. Well, a lot of people are saying that phone that was located in Idaho may have led to someone else. We will talk about that. Also, a violent beating in a McDonald's. We'll explain what led to that. That's coming up tonight on the Debrief at 5 o'clock Eastern. Heather, I hope you'll be watching.
I absolutely will be watching, especially about that fiancé murder. I'm really interested to hear what's gone on with that. So thanks so much, Aaron.
I'll see you later.
All right, ladies and gentlemen, we're going to go to a quick break. When we come back, we'll take you straight back to that courtroom in New Jersey. Welcome back, guys. We are still in the midst of the testimony of this detective. Sanford, you know, he had this whole hearing before the jury got into the courtroom about whether or not his testimony was going to be allowed. Do you think that this testimony is one of the most vital pieces of evidence against the defendant in this case?
Look, fingerprints on a gun, on a knife, are crucial pieces of evidence in any case. But I think the defense lawyer had an obligation to try to keep it out.
Yeah.
But he wasn't successful.
Well, and I think many of us were shocked to hear in defense openings that the defense was going to be that it wasn't him. And that sort of explains why they would want to keep out the fingerprint testimony that connects him so thoroughly, so much more thoroughly than, as you pointed out, a child's testimony. This type of DNA evidence is vital with juries these days.
You know, while guilt has to be proved beyond a reasonable doubt, the truth of the matter is, this sounds like a very difficult defense. Because while there's no obligation on the defendant to testify, and there's no obligation on the defense to put on any case to suggest that they have the wrong person here, sounds to me like a tough defense when they have nothing else to go with.
Well, and we know from reports that this defendant had a very difficult time with his lawyers, was very critical of his lawyers. He's being defended by a public defender. How much does a defendant like that himself steer the defense strategy?
Well, I think here the defendant himself is trying to lay a foundation for counsel that is not adequate on appeal. Look, at the end of the day, I don't know what kind of defense really exists when you have an eyewitness, your own son, ready to testify against you, fingerprints on a weapon. This defense will be very interesting to see.
Well, and that's why this testimony that we're about to get to about the fingerprint on the knife is going to be so vital to this case. And perhaps it was just the defense wanted something to have as an appellate issue. Look,
whether they wanted it as an appellate issue or not, if they got lucky and were able to keep it out, that would be a very, very big win for the defense. But they weren't successful, and that's going to go in just as is the testimony of the 12-year-old boy, we think, on the stand, and it'll be interesting to see his cross-examination if he does testify.
Oh, yeah. I mean, and a child in the courtroom anytime is a difficult thing. But in these circumstances where he's the key witness against his father for the death of the woman that he called mother while his 5-year-old sister in her footy pajamas stood beside her, I mean, my gosh, what a moment for that poor child. And what a terribly hard thing for him. You know, that's why these children need so much help from lawyers and psychologists before they go in and face that type of testimony.
You know, I would suggest also that part of the defense here is going to be perhaps disagreements, arguments, disputes that this 12-year-old boy had with his father to try to plant the idea in the mind of the jurors that what this 12-year-old boy is testifying to is not truthful.
Yeah, that might be a way to handle it, but I don't know that it's a good way. At the same time, I don't know that there's any good way. I mean, to attack a 12-year-old's veracity, especially in the face of a neighbor saying and a friend saying that Jeremiah, the defendant, had been abusing his wife for so long, it's a very, very challenging case here.
Look, one of the overall strategies defense lawyers use is trying to attack the evidence.
Right.
And that's all they got here.
That's right. That's right. Well, it looks as though, are we going to, I thought maybe, oh, you know what, ladies and gentlemen, we are taking yet another break in this courtroom. Before we go to the defense openings, I want to talk to you about these breaks. When they have a lot of sidebars, do you find that that's difficult for the jury to keep with the flow of the trial?
I think that once a jury gets used to sidebars, it doesn't create a problem for them keeping the flow. They have openings which give them a picture of what to expect. They're going to have summations, which gives them the evidence presented by each side in the most positive way, the prosecution for the state, the defense for their client. So I don't think it creates a problem. But what I do think is the jury is very curious what's being talked about out of their presence.
No doubt about it. They're trying to read lips like crazy at that point in the case when they're over at sidebar. Ladies and gentlemen, during this break in the testimony in the actual case, we're going to go back and show you the defense openings and see the surprise to me, anyway, where the defense said that it wasn't him. So let's listen a little bit about that testimony, that opening, rather.
You said you had children. And sometimes you'll ask your kid, who left the cereal out? And that child responds to you with a whole lot of things rather than the answer to the question that was presented to them. So is it a response, or is it just merely, or is it an answer? As each witness comes before you, ask yourself, who are they? What role do they play? Why are they testifying? And more importantly, not what they are saying to you, but what they aren't saying to you. When each person leaves the stand, are you left with concrete answers? Are you left with something that goes you closer to the answer of who killed Tara? Or are you left with more questions? Is your mind left wandering about, hey, that doesn't make sense. That doesn't add up. Yes, they told me this, but what about this? That's true. Listen intently to everything they're saying to you. Analyze everything that is being said to you. Determine whether it really makes sense to you. After the last state's witness testifies, and you were sitting there thinking and analyzing each of their testimony, you're going to be left with more questions than answers. All the pieces won't neatly fit in the puzzle and give you the picture that the government just painted for you. And you'll be left with one choice only, and that is to find Jeremiah Monell not guilty of the murder of Tara O'Shea. Thank you.
All right, ladies and gentlemen, that was the defense opening. I want to talk about that in just a minute, but I want to be clear. They're at yet another sidebar in this case and not a break. You know, these sidebars, while I do know that the juries understand, I do think that they get frustrated when they start to get a little bit of the case and they start to feel like they know where they're going, and then they get yet another sidebar, but sometimes they just can't be avoided.
Look, I think that the sidebars are important. They deal with issues that have to be decided outside of the presence of the jury. But let me tell you something about this opening. I didn't hear much. I didn't hear much of a defense. As a matter of fact, maybe a better opening might have been for the defense lawyer to say, listen to the evidence, they're not going to prove their case, you have an obligation, the judges are going to explain that to you beyond a reasonable doubt. It's not going to happen. I really am not impressed with the, as a matter of fact, perhaps all the complaints this defendant has made about his counsel may have some ground to it.
Well, you know, she said you'll be left with more questions than answers. I'm left with more questions than answers about her opening. You know, she didn't say much of anything. But that said, if you don't have anything to say, she did have the option of just waiving an opening altogether.
Well, I don't know that waiving an opening altogether would have been the right strategy for any defense lawyer. I think she had an opportunity there perhaps to go into reasonable doubt, to go into issues that this jury are going to have to make a determination with regard to. Also to lay the foundation, perhaps, for this 12-year-old boy and the issue of his credibility. She didn't do any of that.
Yeah, I think that's what she was trying to do when she talked about, you know, you're going to question the different witnesses, and then she mentioned a little bit about his age. But I agree with you. I don't think that she did anything to the point. And you're right. I mean, if you don't have an opening to give, talking about the reasonable doubt standard is the best possible thing a defendant can do, because that's a high standard.
And attack the evidence.
Yeah.
I am not impressed with her opening.
Well, it's a difficult thing for a defense attorney when there is no evidence to attack. But we'll go, you know, maybe there is. Maybe she's missing something. But it seems to me as though she's got a really difficult defendant, wasn't willing to make a deal, and was really tied up in a situation where she didn't have a whole lot to say. But we'll see. Ladies and gentlemen, we're going to take a quick break. When we come back, we're going to take you back to that courtroom in New Jersey and see what happens next. You know, ladies and gentlemen, this is difficult, I know, for us to watch. It's especially difficult for the jury to watch, but it is an important part of the case because every one of these crime scene photos has to be identified and marked and entered into the record, not only for purposes of this trial, but for purposes of any appeal. So our system is sometimes slow, but it does bend towards justice, and we'll see what happens here. All right, Sanford, as they continue to go through these photographs, I want to come back and talk a little bit about, I mean, the jury has got to be, they just came back from a sidebar, and now they're watching him identify photographs.
You know, one of the ways to speed things up is to do the identification prior to offering it in evidence, and if there's no objection by the defense, just letting it in by stipulation. Maybe there's going to be an objection by the defense to the photographs, so they can't do that, and it has to be done this way.
Well, it seems that there was. I mean, that probably is the reason for that long sidebar. And we know that this witness was highly contested. There had to be a whole hearing as to whether or not his evidence was going to be scientifically credible enough to get in. You know, again, I keep having to believe that the defendant himself is driving the strategy in this case and saying, you've got to object to that, you've got to object to that. If you have a client who is trying to tell you what to do in a situation like this one, what do?
I think you do what's in the best interest of your client as their lawyer, which isn't necessarily what they want you to do. Because at the end of the day, you have an obligation as a lawyer to present the best defense possible.
Right, but that becomes even more challenging when you've got, we know that this defendant had rejected a plea deal. So what if, as the lawyer, you believe that the best thing would have been in a situation like this, where you've got a young child who's going to testify that he saw these things happen, where you've got a witness, this witness here, who's going to testify about the fingerprints themselves, and now you've got a defendant who refused a plea deal. There's nothing you can do to make him take it.
Well, when you look at the plea deal, 30 years in jail, compared to what he could get, which is life without parole,
right,
that could turn out to be the biggest mistake in strategy that's been made with regard to this proceeding.
No doubt, but he didn't take it, and so the defense has no opportunity to do anything else.
You know,
but
the other aspect is he's been fighting with his lawyer because he tried to get his lawyer discharged and the judge wouldn't do it. So it's a real messy situation.
Yeah, it's a difficult job. Listen, cases like this for a defense attorney, this is a public defender, signed the case, didn't choose it. That's a difficult case for any attorney. But in a situation like this one, where you've got someone who won't take a plea deal, seems to be criticizing you at every turn, and may actually be telling you what to do, that's a challenge.
Well, I think the real challenge here is, given the evidence that we believe will be presented, fingerprints on a weapon, eyewitness testimony by the guy's defendant's own son,
yeah,
I think this is a real tough case for the defense.
So the main witnesses that you're looking to hear from, I mean, obviously the testimony of the 12-year-old son, Maya, is what he goes by. He's named after his father, it seems, Jeremiah. That's going to be compelling and key testimony. Do you think the defendant himself will testify?
You know, I don't know that he has a choice, because number one, if the evidence is so brutal against them, I think he might have to testify, although cross-examination of this defendant could be brutal as well. That's always a very, very difficult decision for a defense lawyer to make. But then again, ultimately, it's the choice of the defendant whether they're going to testify or not.
I was just going to say that. And this particular defendant, I would be shocked if he doesn't testify.
I agree.
I think that he is chomping to testify. And I think that, as you pointed out, I mean, the cross-examination of someone like that, that is taking away the emotion and the tragedy of this. That's the most fun.
Well, it's also a gold mine.
That's right.
Because
that's right.
You have nuggets of gold that you're going to pick up on cross-examination, because it looks like this defendant thinks he knows it all.
Absolutely. And there's just so much to play with. You know, you can play with the fact that he's been accused of having beaten his wife. You can play with the fact that the two children were there. There's just so much to get into as the attorney. How do you figure out where to focus?
Well, I think the focus of the prosecution is to put on the best possible case, and for the defense just to try to chip away at it, and as I said earlier, attack the evidence.
Yeah, and to try to keep him under control when he gets up there to testify, I guess.
Well, I don't know that you're going to be able to control this defendant, particularly in view of all the problems that have existed between him and his counsel prior to trial.
So do you even try to prepare him, or do you just wind him up and let him go?
I think we have an obligation to prepare him and at least listen to what he intends to testify to, and try to guide him in a fashion that prepares him for cross-examination, because that's the most important part of preparing a client for testimony. It's not so much what they're going to say, but it's how you prepare them to be a good witness on cross-examination.
For how, to your point, not just what they're going to say, but how they're going to say it.
And how they present themselves to the jury.
And that's especially difficult when you don't get along with your attorney, because it's hard enough to sort of be cross-examining your client when they trust you and know that you're their advocate and their counselor. But a situation like this one, it's going to be a challenge. Ladies and gentlemen, if you like to watch trials, you are going to want to watch this child and this defendant testifying. We're going to go to break, but we will be right back and go straight into that courtroom in New Jersey.
If he testifies.
Welcome back to the Law and Crime Network. I'm Heather Hansen here with Sanford Rubenstein, and we are going to take you back into that courtroom where the detective is testifying about what he found at the crime scene the day that he came after Tara was stabbed to death, allegedly by her estranged husband. This testimony has been a little bit halting in the fact that they keep having to show the crime scene photographs and take sidebars about those photographs, but now we are hopeful that we will get into some testimony here, and it seems as though that witness is perhaps stepping off the stand. So right now, before we go back into that courtroom, we're going to take you to the top crimes of the day. So we'll show you that, and then we'll be back in just a minute.
Here are today's top crime stories trending on Law&Crime.com and across the country. A couple in Georgia who went missing earlier this week were found dead from what authorities believe was a murder-suicide. Investigators believe two bodies they discovered in a burnt truck on a property in Crawfordville are those of missing Stephen Rhodes and his wife, Melissa. The bodies were taken to a crime lab in Decatur where authorities hope to determine a cause of death. Prosecutors in Indiana filed murder charges against a 21-year-old soldier accused of killing his wife and fleeing to Thailand. Peter Van Bawi Leon, an active duty soldier with the U.S. Army, is accused of killing his wife, Quang Par, whose body was discovered in a trash bin in Indianapolis on December 23rd. Airline records reportedly show Leon flew to Bangkok on December 24th. Leon was arrested in November on charges he assaulted Par and is now wanted for murder and military desertion.
John! Wait!
Hey!
No!
A customer in a Florida McDonald's is facing charges after a video of him assaulting an employee over straws went viral. The customer, 41-year-old Daniel Taylor, is seen grabbing employee Yasmin James at the St. Petersburg restaurant, reportedly because plastic straws weren't readily available. That's when things got crazy.
Hey!
No!
Let her go.
Taylor now faces 2 counts of simple battery. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Welcome back to the Law and Crime Network, ladies and gentlemen. It seems as though there is going to be a new witness on the stand here in the courtroom in New Jersey. While we wait for that witness to go on the stand, Sanford, I wanted to talk to you about the pace at which this case is going. It seems as though the witnesses so far have only been police officers who were there at the scene, but they've gone pretty quickly. Do you think that moving quickly through this case is a good strategy on the part of the prosecution?
Well, I think they're laying the foundation with these officers for what they intend to prove. I think it's good that it's moving quickly. I think the jury likes that.
Yeah.
Important piece of the case, even though it may be boring, is to lay the foundation.
Now, do you start with those foundational witnesses rather than, because I always think about the primacy and recency effect, or the fact that the first people that you hear from and the last people that you hear from tend to be the ones that you remember most closely and better. So do you weigh towards laying your foundation at first, or do you weigh towards maybe calling one of your most emotional, sympathetic witnesses for the jury first?
I would think it's important to lay the foundation so you don't have objections to the witness's testimony. But I like to save my best witnesses for the end, because that's what the jury is going to remember most, the witnesses they heard at the end of the trial as they go to deliberate.
Yeah, let's go to the courtroom and to see who this next witness is and whether or not that will be an emotional witness for the prosecution. All right, ladies and gentlemen, so this detective is another detective talking about the crime scene, identifying some photographs and talking about what it is that he found. At some point, does this get cumulative, Sanford, or are you really just continuing to set the foundation?
Well, I think they're continuing to set the foundation, to lay the foundation. That's so important. Boring, but very important, because at the end of the day, the complete record will be what the trial appellate court will use to make a determination with regard to whether, if there is a verdict, it stands.
Well, and that's the problem, isn't it, that there's 2 different trials going on. One is the trial to the record for the appellate, and one is for the jury, who's probably saying, we just heard this, why do we need to hear it again? But you really have a responsibility as trial counsel to make sure that that record is good for any appellate counsel who comes behind you.
You know, as a trial lawyer, the philosophy I have is, let's win the trial first. Worry about the appeal later.
I do too. I bet your appellate lawyers don't like that very much.
But you want to lay the No, but you want to put in a record everything that you need. But the real focus of a trial lawyer is that jury and getting that jury to go the way you want them to.
That's absolutely right. And let the chips fall where they may when the appellate lawyers pick up that record a little bit later. But they do, to your point, they do have to get those points down. They will continue to get those points down, ladies and gentlemen. We're going to take a quick break, and when we come back, we'll go right back to that courtroom in New Jersey. All right, guys, we have yet another detective identifying photographs, showing them to the prosecution, showing them what. If you're the defense attorney here, are you going to cross-examine this guy, or are you going to ingratiate yourself to the jury by being like, okay, enough of this, let's move on?
Look, if I think I can keep something out, I will.
Right.
Otherwise, I don't know that it's going to help to be combative.
Right.
I think the real important testimony in this case is going to be that 12-year-old boy. I can't wait to see his direct and also to see the cross.
Well, and let's talk a little bit about that process, because in my experience, and I have experience with kids in the courtroom, but not in Jersey. I do some work with kids in Pennsylvania. They get their own attorneys, guardians, who are representing their interests throughout the process. Do you think that that's probably happened here?
It may very well have, but I don't see how it makes a difference. This kid is going to testify to what he saw with his very own eyes. And if he saw his father kill in plain sight, that's brutal.
Yeah, you know, it's funny. Before I decided to be a lawyer, my degree is in psychology, because I wanted to be the person who interviewed and helped those kids. Because, to your point, he is going to be forever marred, forever remembering not only the moment of the death of the woman that he called mother, but also having to then testify against his father. Do you think that the emotion of that is going to impact the way the defense goes about cross-examination, and should it?
Well, I think that the defense is going to try to attack his credibility. If the defense is, in fact, what they have indicated, that we got the wrong guy, how can you not believe his son when he testifies that you got the right guy?
Yeah, I got the impression from the defense opening that maybe they were going to say the way he was questioned, he answered the questions themselves were the problem and not the kid's answers. I don't know. We're going to have to see.
The other thing we haven't seen yet is what angle the kid saw it from. Did he have his father in clear view when he saw him be a killer? We don't. And 48 times. This victim suffered 48 stab wounds.
Yeah.
That is just brutal.
Yeah, it's a terrible crime, a terrible case, and a terrible defense for this defense attorney who just doesn't have much to do with it. Well, ladies and gentlemen, we're going to take you to another break. When we come back, we'll go back to that courtroom and see how the prosecution is going to wrap up their day. Welcome back to the Law&Crime Network. Well, we are now, Sanford, seeing something a little bit more interesting for the jury in the courtroom, and that is, they're showing it to you there on the screen, that is the blanket that the victim was wrapped in when the police officers arrived. Now, that is a key piece of testimony, not only with respect to DNA evidence and so forth, Sanford, but also with respect to, as you pointed out, the credibility of the young boy who's going to testify. Do you think that they're going to be talking about the specifics of this blanket in that testimony?
Well, I would think the most important thing about the blanket is that it's probably soaked with dried blood, and the jury sees that. That's a serious piece of evidence psychologically.
Yeah, I mean, from this angle, you can't see so much dry blood, although they are talking about it with respect to what's being found on that blanket. But certainly, you know, a little bit earlier in the testimony, they were showing the jury pictures of what the room would have looked like and where the body was lying and where the weapon was found and so forth and so on. That's a compelling way to take some of this testimony that's been really slow and make it a little more interesting. And this blanket is another way to sort of get them, if they've been dozing off, they're a little bit more awake right now.
Well, I think the issue is more that it's going to make their case than worrying about keeping it interesting. Well, because they've got to put enough evidence in to have the record they need on appeal, as well as to convince this jury, even though it doesn't appear at this point to be very difficult, of the guilt of this defendant.
But they've got to keep the jury listening and engaged in the testimony, which a blanket filled with blood is much more likely to do than some crime scene photos that the jury doesn't even seem to be looking at a whole lot.
I totally agree, but they're all needed for different reasons.
Oh, absolutely. But now we finally have something where the jury is like, well, let me see. I would bet, we don't get to see the jury, but I would bet you've got jurors leaning forward for the first time this entire trial.
And I think it also affects them emotionally. Remember, 48 stab wounds.
No doubt.
There's got to be a lot of blood on that blanket.
Not only does that, but then you've got to remember there was a 5-year-old girl with her brother that went over to the neighbor's house and said, Mommy just got killed by Daddy. So, and then you see this blanket that has the Disney princesses on it. You know, I don't remember which princesses they were, but 2 of the Disney princesses on it covered in blood stains. I mean, that's a compelling visual for this jury, especially as they get towards the end of the day. The thing that the jury is going to be going home tonight, not talking to their family about, or at least not supposed to, is the memory of this bloody blanket with the Disney princesses on it.
No, I agree.
Yeah. All right, ladies and gentlemen, we're going to take you to the top crimes of the day, and when we come back, we'll see what they're going to be doing in that New Jersey courtroom.
Here are today's top crime stories trending on Law&Crime.com and across the country. A couple in Georgia who went missing earlier this week were found dead from what authorities believe was a murder-suicide. Investigators believe 2 bodies they discovered in a burnt truck on a property in Crawfordville are those of missing Stephen Rhodes and his wife, Melissa. The bodies were taken to a crime lab in Decatur where authorities hope to determine a cause of death. Prosecutors in Indiana filed murder charges against a 21-year-old soldier accused of killing his wife and fleeing to Thailand. Peter Van Bawi Leon, an active-duty soldier with the U.S. Army, is accused of killing his wife, Quang Par, whose body was discovered in a trash bin in Indianapolis on December 23rd. Airline records reportedly show Leon flew to Bangkok on December 24th. Leon was arrested in November on charges he assaulted Par and is now wanted for murder and military desertion.
John, wait!
Hey,
No!
A customer in a Florida McDonald's is facing charges after a video of him assaulting an employee over straws went viral. The customer, 41-year-old Daniel Taylor, is seen grabbing employee Yasmin James at the St. Petersburg restaurant, reportedly because plastic straws weren't readily available. That's when things got crazy.
hey,
No!
get the police. Let her go.
Taylor now faces 2 counts of simple battery. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Welcome back to the Law and Crime Network, ladies and gentlemen. That poor girl went to work for her shift at McDonald's and had to fend off an angry customer. We'll see what happens with that case against that customer. It is really a violent scene to watch, and she held her own, didn't she, Sanford?
Yes, she did. I think he got more than he expected.
Absolutely, and
He
good
wanted
for
a
her.
straw, and
Good
he ended
for
up.
her.
But he was, as you can see, what, 6 foot tall? She's a small person, and he grabs her.
Yeah, it's
you don't do something like that.
Absolutely not. Absolutely.
And it looks like she was just trying to fight him off.
As she should. You know, good for her to not just let him go after her. It's a real shame. We'll see what happens with criminal charges against him. So I want to talk, they've ended for the day there in New Jersey. So the jury has had a day where they've had some openings that were confusing, to be sure, because here you've got the prosecution giving some specific pieces of evidence that the jury can expect to hear about the blanket, about the fingerprints, about the knives, about the stab wounds, and about the son testifying. And then they've heard from the defense that this is all not that clear and maybe he didn't do it. The day ended with that blanket. Who had the win for today?
Well, I think it's clear the prosecution had a good day, and the day ended very well for the prosecution with a bloody blanket.
Yeah, it's funny, you know, you can't control that, right? As a trial attorney, you can try, you can try to schedule your witnesses in a way that, as you said, you always want to end with your strongest witnesses to leave that in the jury's mind, and you can do that. But you can't control how a day goes and whether you have to start across or how it ends. But sometimes, days like today for the prosecution, it ends exactly where you want it to. And now you've got a jury going home thinking about that strong opening and that bloody blanket.
But let me make one comment, because so far I think we've said it's been strong for the prosecution, weak for the defense. At the end of the day, you never know what a jury's going to do.
That's right.
You never know. Also, you have 12 jurors. 1 juror could be a holdout. could be a hung jury. So you never know what a jury is going to do. Here, he turned down 30 years. He's rolling the dice. Right. Maybe he won't get life without parole, even if he's convicted. So again, there's a lot of importance to the reality of today's world, and that is, again, you never know what a jury's going to do.
Well, and that's probably why the prosecutors offered him that deal, because that deal seems like, it does seem as though they have a pretty open and shut case, but because you don't know what a jury's going to do, it makes it worthwhile for them to at least make that offer.
And we don't know what the defense might have. Maybe they do have something. We just don't know. It wasn't presented on the opening as it should be if there was something, but we don't know what the defense is going to present as a defense.
Yeah, we'll see. But let's go back and look at what the prosecution presented in their opening, and then we'll get a chance to maybe look at what the defense presented as well. But first, the prosecution's case, as stated in their opening earlier today.
She asked Jeremiah, where's your mom? Jeremiah looks at her and says, Mommy is dead. Daddy killed her. Imagine the shock and how stunned she was when she heard those words. She asks him again, this is not something to kid about. Where's your mom? And he gives the same response. So Glenn, Crystal, and James get to the house. 9701 Raven truck. And upon going into the house, they discover the horror that had occurred.
There you go, ladies and gentlemen. That's the prosecution's opening. Mommy is dead and Daddy killed her. What a way to end the day with that thought in the jury's mind as they looked at that blanket and with the Disney princesses on it. Now, to counter that, the defense opening was also given this morning. Let's take a look at that.
Listen intently to everything they're saying to you. Analyze everything that is being said to you. Determine whether it really makes sense to you. After the last state's witness testifies, and you were sitting there thinking and analyzing each of their testimony, you're going to be left with more questions than answers. And you'll be left with one choice only, and that is to find Jeremiah Monell not guilty of the murder of Tara O'Shea. Thank you.
And that was the defense opening. Sanford, I don't know what...
Well, I'll tell you what I'm wondering as I watch both of them. I'm wondering if in some way, shape, or form the prosecution is going to try to use the testimony of the neighbor with the statement of the son saying, Mommy's dead, Daddy killed her, instead of putting the son on the stand for whatever reason they may not want to put him on the stand, using some kind of exception to the hearsay rule to get it in. As a lawyer, as a trial lawyer, that's going to be very interesting to see if that's their strategy, if that's what they're going to try to do to prevent to have the 12-year-old son from being cross-examined. They use that as a way to get it in. Whether they'll be allowed to get it in or not, it's clearly hearsay. It'll be very interesting because there are exceptions to the hearsay rule.
Yeah, I mean, the hearsay rule itself is one of the most challenging things in law school. An evidence class in law school, that rule 804, Federal Rule of Evidence, it is the hardest rule to understand because there's so many exceptions.
And that's what makes the rule so interesting, because there are so many exceptions to it, and one of the most important talents of a trial lawyer is their knowledge of the law of evidence and trying to use the law of evidence to their advantage in a trial.
And that's why I brought it up a little bit earlier today, because we didn't hear from the prosecution, you'll hear from little Maya. He never said that. He never made the promise that you were going to hear from the child. What he said is, this is what the child said. And so it certainly could be that he's going to at least try to get that in through the witness who heard it, the neighbor.
And of course, if he can't get it in that way, then he has the option of calling the 12-year-old boy. I think, though, this jury is going to really want to hear from the 12-year-old boy.
You would think so as well, although maybe they hear from the police officer who interviewed him. I mean, there's a lot of ways of getting around that, and we'll have to wait and see, ladies and gentlemen. So we're going to take you to break, and then we're going to talk a little bit about what we have coming up this year and even more soon next week. Did I tell you we have a lot of interesting trials coming up, Sanford, but I want to talk to you about the one that starts next week, and that is the case against Chase Merritt, who is accused of killing the entire McStay family. That is Joseph McStay, his wife Summer, and their 2 young children, Gianni and Joey Jr., with a sledgehammer over a business argument, it seems. Again, another very emotional case that involves children. Jury selection is going to be difficult in that case as well.
I think one of the other problems with proving a case that happened in 2010, in 2019, is a challenge, because witnesses may have not remembered everything that one would expect to remember if the trial was in a reasonable period of time after the alleged crime occurred. Evidence may not be available. So I think the prosecution in that case has an extra challenge because of the fact that this crime that is alleged occurred in 2010. A horrid crime, killing a whole family. But it is 2019, and that happened allegedly in 2010.
Yeah, and to your point, scientific evidence, so DNA evidence and all of that. Not only is there a possibility that some of that evidence could have been lost in those years and no longer testable, no longer usable, but also the changes in the way that they use the technology could impact it because of that time
As
frame.
well, the simple recollections of witnesses.
Right.
9 years later can be attacked on cross-examination because of the time frame.
And that's a really good point, especially if they're going to get into the specifics of their business relationship. That case is going to be a little bit more difficult to prove. Now, the other case that we have starting next week is also fascinating. This case against Jeffrey Dalton, we talked about it a little bit before. He went on this mass shooting spree, and it seems as though, it doesn't seem as though, it seems like they've admitted this, the defense is going to be an insanity defense. What do you think of insanity defenses these days, given everything that the layperson knows about mental illness and mental health issues?
Very difficult defense. It really depends in part on the witnesses on each side.
That's right.
The psychiatrists who are going to testify for the state, and the psychiatrists that are going to testify for the defense.
Yeah, these are the expert witness cases. This is the battle of the experts that we talk about so often, where the jury is going to weigh the testimony, the credentials, the credibility always of the expert witnesses for the prosecution against the expert witnesses for the defense. Now, one of the things that always intrigues me is that as technology advances in cases like this, they start to talk about brain scans. Because now brain scans can actually show things like, you know, CTE, like in concussion cases, and different types of brain injury that may contribute to an insanity defense. What do you think of that type of evidence, and do you think it's going to reach the level of credibility that it can be used in a case like this?
Well, look, if an expert can testify with a reasonable degree of certainty that it was a brain injury that caused someone to become insane, you got a shot.
Yeah. Well, we're going to take you, ladies and gentlemen, to a little roundup of that case so you can know what it is that you have to look forward to next week.
A former Michigan Uber driver could get life in prison for a 2016 shooting rampage that left 6 people dead. Prosecutors say Jason Dalton killed 6 and critically injured 2, including a teenage girl. The frenzy began while Dalton was transporting a passenger from Kalamazoo College. Dalton claimed he began seeing strange symbols on his phone, and a sensation came over his body. He began driving erratically through the streets, frightening the rider, who was eventually able to escape. Dalton told police he drove back to his home and began preparing his weapons. He said he drove to an apartment complex intending to pick up a rider. Instead, he found 25-year-old Tiana Carruthers. Dalton shot her multiple times. Tiana managed to survive. Dalton continued, reportedly fatally gunning down 53-year-old Richard Smith and his son, 17-year-old Tyler Smith, at a car dealership around 10 p.m. The final shooting occurred less than 20 minutes later, when Dalton allegedly shot 4 women and a young girl in a Cracker Barrel parking lot. Sisters-in-law Mary Lou and Mary Jo Nye, Dorothy Brown and Barbara Hawthorne were among the dead. Barbara's family friend, a 14-year-old, sustained a gunshot wound to the skull, but managed to survive. In interviews with police, Dalton said it was like it wasn't even himself. He further explained to a psychiatrist, "It almost seemed like my phone could control me," despite reportedly having no history of psychiatric delusions. In spite of his claims, he was found competent to stand trial in April 2016. An appeals court threw out the confession Dalton made to police, citing Miranda violations. Dalton pleaded not guilty to the charges. His defense attorney has expressed intent to use an insanity defense. Dalton faces 6 counts of murder, 8 weapons charges, and 2 counts of assault with intent to murder. For the Law and Crime Network, I'm Aaron Keller.
Well, there is a lot to unpack there, a lot to look forward to with respect to trial watching, because you've got this insanity defense, but he didn't have a history of any sort of mental health issues. Does that help or hurt? Is it going to be some sort of psychotic break argument?
Well, I think if, in fact, he had a history of psychiatric problems, it would help. Right. The fact that he doesn't helps the prosecution.
The other thing that's going to be interesting, we only have a couple minutes to wrap this up, but we're going to hear probably from 2 victims. How hard is that going to be for the defense to get over?
Well, I think that leaves a lasting effect with the jury. And even though the judge charges the jury not to let emotion play a part in making a determination, it's going to be an emotional day.
Yeah, it's impossible. It will be an emotional day, one that you will definitely want to tune in for, ladies and gentlemen. In the meantime, we're going to go to a break and be right back.